Today I just want to talk about the relevance of the coastal hazard provisions in the New Zealand Coastal Policy Statement, and how they're sort of relevant to the potential change to the Christchurch District Plan to address coastal hazards. Now I've got no idea of the full scope of what that plan change is going to be, and I don't intend to put anybody like Mark Stevenson on the spot about this. So I'm just going to proceed on the basis that it is a sort of ground up review of all the existing provisions of the district plan. It may well not be, but that's how I've prepared my that's the basis for my presentation. As Warwick sort of indicated, I am sort of familiar with the history of the current district plan provisions. He may have sort of overstated my contribution, but I am familiar. I sort of helped out in the background in terms of the independent hearing panel process. Now there are a couple of features of that process that actually worked against community involvement, and sort of my understanding is that there won't be a repeat of that or those failings in the next process. And in particular, sort of the decisions on natural hazards were made on a two-stage basis. So by the time sort of people like people in the community like CCRU sort of became interested, to realise that actually it was probably too late to challenge some of the previous findings of the independent panel. But regardless, I think sort of Warwick and his cohort had quite significant success during the process in terms of I'll call it a relaxation of the rules applying to areas such as the South Shore. But unfortunately, that relaxation of the rules didn't sort of go according to plan. And there were some difficulties in interpretation which led to a further process under the Regeneration Act, which involved sort of further amendments to the district plan. I'll sort of go over the provisions of the current district plan sort of very briefly towards the end. The other thing is just I want to talk about sort of when I was preparing this presentation. So I had in mind sort of geographical context. So I was talking about this area, South Shore, Brighton, Red Cliffs, and that's principally because, you know, sort of you've got significant existing investment and development, and so you know, sort of the coastal hazard provisions, a different approach may be ultimately what's required, which will be a continuation of the current approach actually. There you go. So just briefly, the scope of the presentation, I just want to talk about the obligations of the local authority. I want to talk about the hierarchy of RMA instruments, which the New Zealand Coastal Policy Statement sits at the top of the tree. Then I talk about sort of how the provisions of the New Zealand Coastal Policy Statement have been interpreted by the courts so far. There's actually limited case law, thank goodness. So I didn't have to spend days reading a whole load of cases. And I'll just briefly refer to the current provisions of the district plan and the regional policy statement, which is obviously an extremely relevant document for any changes to the plan. Okay, so the management of natural hazards or obligations on local authorities to manage natural hazards, it's nothing new. I mean, sort of there are lots of plans over the years that are replete with provisions sort of aimed at sort of managing development within hazard-prone areas. And a huge generalization, but a lot of these previous plans actually generally sort of manage development in areas where there's a history of inundation from, say, for example, flooding or sort of coastal erosion, etc. But of course, the requirement to take into account sea level rise adds a sort of actually a further sort of layer of complexity, to say the least. Okay, but in terms of the resource management itself, I want to start with Part 2 of the Act, And this is a very recent inclusion as a matter of national importance in the Act, and it requires local authorities to recognise and provide for the management of significant risks from natural hazards. It sort of underlined the word significant for a reason, because I don't know what it means, and the chances are that everybody here in this room doesn't know exactly what it means. Sort of in a different context within the RMA, in the sort of a qualitative assessment of adverse effects, it's usually regarded as more than minor. Something that's more significant effect is something that is a more than minor effect. So the other thing, of course, is that it incorporates or mandates a risk-based approach towards the management of natural hazards. Now, a lot of local authorities have been taking a risk-based approach anyway, but this is a specific requirement included in the RMA, and it actually came out of the Royal Commission on the Canterbury earthquake sequence. That's the rationale behind its inclusion, and the Commission actually found that the local authorities weren't properly managed or not fully managing the issue, mainly because, or one of the reasons why, is because it wasn't accorded a high significance in the Resource Management Act. But now it is a matter of national importance. That means local authorities can't bury their head in the eroding sand. They have to do something about it. They have to provide for this issue in the local authority plans, district plans, regional plans, etc. There are other obligations, sections 30 and 31, about the avoidance or mitigation of natural hazards. Right, and also in terms of the hierarchy of instruments prepared under the Resource Management Act, at the top of the tree we have national policy statements, and below that we've got regional policy statements, and then below that we've got district plan. And so those subordinate documents, so the district plan must give effect to the regional policy statement, must give effect to the national, anything above it in the tree. The higher order documents, the lower order documents have to give effect, and that means they must implement. It's fairly straightforward, really. And so there's an obligation to implement. So if you've got policies in the New Zealand Coastal Policy Statement that direct a certain outcome, the district plan at the bottom has to give effect. It has to implement those policies. It's a legal requirement. Okay, New Zealand Coastal Policy Statement, sort of the focus of the presentation. It's the only mandatory national policy statement under the Act, and it's the state policies in order to achieve the purpose of the Act in relation to New Zealand's coastal environment. And the policies talk about appropriate subdivision use and development in appropriate locations. It talks about preservation, protection of natural character, etc. It also talks about coastal hazards, obviously, and it lists significant surf breaks in New Zealand for some reason or another. Might be interesting to people here. It's developed by Board of Inquiry, or recommendations of the Board of Inquiry, and it sort of responds to lack of criticism, or a criticism of lack of clear direction in the earlier 1994 version. I don't want to sort of get into too much detail about national policy statement process, but one of my observations is that it, generally speaking, while it's open to everybody to participate in the development of national policy statements, in reality the vast majority of the population have got no idea that a policy statement is being developed, and so there's very little opportunity for local viewpoints to be put forward in the development of these statements. well, they can actually have a profound effect on the plan provisions that affect communities. The other thing as well, the other observation is that national policy statements are developed by sort of policy gurus in sort of Wellington. And so rarely, if ever, I don't think ever, they would actually road test the provisions to see what the impact of these provisions would be at the coalface. They unfortunately leave that to the council planners and to applicants for consent. So I'll just go through some of the provisions and provide a brief commentary on the provisions. And the first one is, like, this is the key objective. It's to ensure coastal hazard risks taking into account climate change are managed by primarily locating new development away from areas prone to such risks, and then considering responses like management treat, and then protecting or restoring natural defences. Look, there's a clear direction in that objective that new development, it needs to be located away from risk-prone areas. I'm not entirely sure what actually constitutes new development for the purpose of that objective. It sort of, I'll give you two examples. So you may have a large greenfield subdivision where you're sort of rezoning rural land to residential land in an area subject to hazard. Quite clearly that's new development. Okay, a replacement of an existing dwelling, is that new development in a hazard-prone area? An extension to somebody's house in a hazard-prone area, which is in reality is something that happens on a regular basis here. People have sought extensions to the existing houses in South Shore and have encountered difficulties. Okay. Are those minor extensions captured? Do they fall within the definition of new development? Not sure. The other thing is that I've noticed is I've underlined the word prone to such risks. And again, from a sort of a legal perspective, I want to know what that means. In prone, it's defined as likely or liable to, which means it's more likely than not that the risk will occur. And in my view, that sort of has implications for assessments that are acknowledged of the different scenarios in terms of sea level rise that are acknowledged to be less than likely to occur. Warwick, you've got a particular opinion on this. Because the basis for some of the sea level rise projections are sort of extreme worst case scenarios. I'm not going to argue with the fact that there won't be sea level rise, but I'm just saying, do those extreme worst case assessments fit within the likely to or prone to? Not sure. The other question in my mind is that, hark back to section 6, which is the management of significant risk, which is undefined. And so if objective 5 addresses all risks, is it consistent with the matter of national importance? I have a question in my mind as to whether or not the provisions of the New Zealand Coastal Policy Statement actually need to be reviewed in light of the new matter of national importance, but that's not for me to determine. This is the extremely wordy policy. Please do not go through it. In your own leisure, as a sedative perhaps. But it talks about what needs to be taken into account in terms of the risk assessment. The various factors in terms of sort of physical processes, actually geomorphological character of the coast, etc. Those are technical factors that need to be taken into account. And it turns out it is, in reality, it's an extremely complex assessment that's required on behalf of local authorities. And that's just to provide the basis for future decisions, for future planning. So the technical assessments, as I said, they inform decisions as to what approach should be taken into the future, whether it should be sort of management retreat or whatsoever, or should be some adaptive process that should be adopted. These technical assessments, nobody likes them. No, they come under enormous scrutiny. Okay, and a couple of examples, one of which of course is local, is the 2015 assessment that was subject to quite strident criticism from local community, perhaps CCRU, and also there's the Kapiti Coast example as well, where the information, where the assessment was actually referred to on people's property limbs or land information memorandum, and caused a lot of fuss, shall we say. Hold on, have I finished the commentary? The other thing is I've noted is, again, from a legal perspective, the different language that's used in that policy. Again, it talks about what's potentially affected, high risk, likely effects of, and that seems inconsistent with the objective. It seems inconsistent with Section 6 as well. And for example, the use of the word potentially, it's a possibility only, supported by some objective analysis, which is an extremely low threshold. And I think the judge in Weir, that Kapiti Coast case, he referred to as this might be they potentially might something just beyond the realms of fancifulness. Might be sort of, so something slightly more than incredible or something, so it's a very, very low bar to be required to identify areas that are potentially affected, say. Of course, it's potentially is completely different than likely to be subject to a risk, which is traditionally regarded as something that's more likely than not, which is there's more than a 50% chance of something happening. And again, sort of a high risk, what does that mean? It's an undefined term, but from a risk perspective, you look at the likelihood of the event occurring and the consequences. So if you can imagine like a simple continuum, you've got a high probability of event occurring, and there are significant consequences. That must be a high risk. But at the other end of the continuum, you might have a high risk of an event occurring, but very low consequences. So like the inundation might be on rural land where there's no built development. But it's that area in between those two ends of the continuum is where all the debate is going to be had. Because you've got uncertainty as to the likelihood of the occurrence, but you might have some idea of the consequences if it occurs. So it makes it very difficult in terms of coming up with a regulatory approach to deal with high risk. And the other thing as well is that it's inconsistent with the significant risk in Section 6. This is a key policy which talks about, it's got different obligations. The first one is to avoid the risk of social and environmental and economic harm from coastal hazards in areas potentially affected. Again, extremely low bar. Avoid redevelopment that would increase the risk. And then it talks about encouragement and discouragement of hard protection surfaces. Again, as I say, there's no prioritization of areas as there is in the following policy about high risk areas. it's inconsistent with the requirement to manage significant risk. Really, in theory, this is a policy that could apply to areas where the risk is absolutely negligible. I would be surprised if that was the approach that was ultimately taken, but ultimately, sort of when you talk about avoidance, that's very directive, okay? But the fundamental point is that those policies don't seek to avoid development as such. It's to avoid the increase in risk. And so there may be approaches that can be taken in terms of design approaches, etc., where the risk can be avoided, but it's not really clear. The other thing is the reduction of risk is encouraged in that policy, but that's inherently weak. Natural defences, quickly flick through this because there's that is a priority to actually to encourage the protection and restoration of natural defences. So it expresses a clear preference over hard protection surfaces as a general rule. As I'll talk about later, there are circumstances where hard protection surfaces are to be considered appropriate. And I think that preference was, for natural defences, I think it sort of reflects the fact that it's the Department or the Minister of Conservation who actually developed the policy statement, because there are quite significant policies elsewhere that talk about preservation and restoration of natural character. And it's clear from the policy that says, by comparison, hard protection structures in the wrong location can result in quite significant adverse effects to natural values. I'm not sure, as I've, like my last point, I'm not sure how relevant this is to this geographical area, but it might be something to consider in long-term approach. Again, policy 27, this talks about existing development, and it talks about likely to be affected, which is more likely than not. And it talks about different strategies towards reduction of coastal hazard risk. And of course this squarely relates to existing urban areas, including, I'm not quite sure this is the right words in it's the written sort of handout slightly different to this, unfortunately. But here it needs to be established that it's likely or more likely than not areas will be affected by the hazards. Policy 27 requires a long-term, multi-generational sort of management approach. Sort of involves monitoring of levels of the risk, and then adjusting the solution, shall we say, or the strategy, depending on whether the risk is actually increasing or accelerating. And it could ultimately include removal of existing development in the worst case scenario. That policy, of course, doesn't rule out hard protection structures as being necessary in some circumstances to protect existing investment, but it isn't the preferred option. I want to talk about just a few cases where the provisions of the Coastal Policy Statement have been interpreted and applied. There haven't been too many cases, as I said, fortunately. The first one, which is the King Salmon case, which didn't talk about coastal hazards. It was about sort of highly prescriptive avoidance of adverse effects policy on natural character, adverse effects on natural character policies. And it said that those policies are bottom line, essentially bottom lines, but it did go on to sort of recognise that if strictly applied, that would essentially prevent anything from occurring in some identified areas. But one of the lessons to be learned is that the more directive the policy in the New Zealand Coastal Policy Statement, like avoid, the more directive that policy, the clearer the obligation is on regional councils and district councils to give effect to that policy. Well, what I could say is the coastal hazard policies in the Coastal Policy Statement, they're not quite as prescriptive overall, when read overall, in comparison to the natural hazard policies. And then there's a couple examples of mainly sort of resource consent applications. I'm not sure if any of you will be familiar with these areas. Certainly I'm not familiar, but that's the first one is like Peninsula, Tasman Bay, Moutere Inlet. And this was Holt Harvey. They got their consent application declined for a proposal to develop 6 residential allotments on rural land. And all the experts, including the experts for Holt Harvey itself, agreed that the land would be subject to significant coastal erosion and inundation because as a result of climate change. Holt Harvey said, well, okay, we'll deal with that with sort of minimum height levels, floor levels, and relocatability of the buildings. Can relocate the buildings. But just in terms of the extent of the effect, I think the conclusion from the court was that actually 50% of all the allotments would be eroded within approximately 50 years on the Tasman Bay side, and on the Moutere Inlet side, so about 25% would be eroded. So quite clearly the future for those allotments was bleak in terms of the impact of coastal erosion. So the court actually sort of dealing with the policies talked about specifically policy 25 about avoiding the increase in risk, and it said that, well, relocatable houses under that policy, it's a way of reducing the risks. But fundamentally what it says is that their policy in the New Zealand 25, it isn't a prohibition on development as such. But if you are going to develop, the key message to achieve those policies is that you need to actually ensure that risk isn't increased. Okay. The second one. Okay. Well, I just said my reading of the case. Look, the evidence of effects was so overwhelming that it was a dead duck from the outset, because there was a clear conflict with the provisions of the NZCP, the Coastal Policy Statement, and indeed other provisions of other plans. And in addition, the court sort of said there were numerous significant deficiencies in the applicant's case. And this is about, so there was a single access point into the allotment, into the development, which the court found would probably be lost because of erosion, and said, well, if you can't get your truck in there to take the houses away, how are you going to take the houses away? And they went, oh, we'll take them away by boat. Okay, how are you going to do that? Oh, I'm not sure. And so Holt Harvey had offered to provide a sort of an initial sum to sort of upgrade the road, and the court said, well, what about future maintenance of the road? Who's going to do that? And so basically there were too many holes in the case. Right, and so there was a bit of discussion about voluntary assumption of risk, and sort of the cases actually aren't particularly consistent about that. It's like, if I agree to assume, if I, the landowner or the developer, agree to assume the risk, well, what's the problem? If there's no risk to the wider community, then what's the problem? No cost to the wider community, then what's the problem? But in this case, those considerations didn't have a particular great deal of weight, which different in this one. This is Hawksby Wairoa case. Again, this was for 5 new allotments in an existing residentially zoned property. 2 of the allotments were in the highest risk coastal hazard zone, and the applicant offered fairly typical but robust, in this case, conditions about minimum building platform heights, relocation of houses, and when there was a certain trigger point, and that's a certain level of erosion. And then to top that all off, there was a bond, quite a significant bond, held by the council to ensure that when that trigger point arose, the consent holder wouldn't simply abandon the property at the cost to the community. So the bond was there to make sure that that didn't occur. And again, so there was in this case, there was a little bit of a dispute amongst the experts about the level of adverse effects. But the court actually, adopting a sort of a pragmatic approach, sort of concluded that the trigger point would arise in approximately 20 years. So they could have the house potentially only for the houses on these allotments potentially for only 20 years. It's looking pretty grim for them, but the court thought, well, that's sufficient. They were satisfied that that was okay. And actually, the court had a look at the various different provisions and acknowledged that the development didn't actually match up completely with the objectives and policies, but it did recognise that placed a great deal of importance on the fact that there was a voluntary assumption of risk, and also the fact that nobody else would be affected by the proposal. No other land, says, risks to other land will not be aggravated by the proposal, and adverse effects on the lots themselves would be mitigated by the removal requirements. I'm actually surprised at that outcome, given the evidence, clear evidence of impending adverse coastal erosion. Well, like 20-year lifespan. Okay. And I've tried to reconcile it with the decision of the New Zealand Coastal Policy Statement, which talks about locating new development away from, and this was quite clearly new development, locating it away from areas of risk or risk-prone areas. I could only reconcile it with this if it is an acceptable alternative to avoidance, that if you offer sort of issues like relocatability, minimum floor height levels, etc., and bonds, etc., that simply avoids an increase in the risk of social, environmental, or economic harm, which is the requirement, to the wider community, as opposed to the individual landowner themselves. But so in that case, if you talk about a risk-based approach, so you've got an extremely high probability of the effect occurring, but the court would obviously be satisfied that there were no consequences. The other point is, one of the most, I read the case as one of the single most influential fact is that the actually property had been zoned for residential development for at least 40 years. Quite surprising, really. Finally, this is a plan change. It's actually not that area there. We're talking about this V-shaped in here. So this, the context of that, there was a council plan change 22, Tasman District Council, what is sought to identify areas for growth of Ruby Bay. And the key focus of the exercise Plan Change 22 would have been to avoid areas, we talk about urban growth, is to talk about avoid areas that would have been subject to coastal hazard risk. Now the Gallaghers, the applicants themselves didn't actually challenge the provisions of the plan change, and that's actually that's important, but rather they actually sought like a spot zone for their property, for that land, to actually have 13 residential allotments on that land. All dwellings would be relocatable, etc. The council didn't agree with the Gallaghers and actually sought to have any further development on that land prohibited. Bearing in mind that just before that plan change, the council had actually agreed to a subdivision of the land to create 2 allotments instead of 1, but that's by the by. But in this case, there was extensive expert evidence again on coastal erosion, stormwater, seawater inundation, and the court found on the evidence that the property would be subject to inundation to depths of 2 metres. So on that basis, it was a high risk property in terms of coastal hazards. And so there the court focused on the directive nature of their policies in terms of ensuring that risk is avoided by locating the new development away from risk-prone areas. Yeah, because as I said, the purpose of the plan change was to identify areas for growth, and so faced with a simple decision of should we have growth in risk-prone areas or non-risk-prone areas, I think it was a pretty easy decision to make ultimately. Because essentially this is talking about greenfield rezoning of rural land, so it's quite clearly falls in the new development category. And so while Gallagher is probably the leading case on the application, or the most relevant case on the application of these provisions, it actually doesn't deal with a planning document that is fully contested. As I said, they had no argument with the overall thrust of the plan change. They just wanted some more development on their land. They wanted an exemption from the plan change. So the approach to the plan change in terms of regulating land use wasn't really challenged by them. And in actual fact, I'm not aware of any decisions where the planning approach has been challenged in the court. Have anything else? Oh, that's probably it. Almost there. So I just sort of finally, I just wanted a brief overview of the current district plan provisions, and sort of focused on the high flood hazard management areas that are identified on the basis of increased inundation from sea level rise. And the plan includes a mechanism in certain areas, including South Shore, it's called the residential unit overlay. And again, it's an exception from an otherwise strict avoidance policy for all forms of development within the high flood hazard management areas. And so it allows for, as of right, replacement and repair of buildings existing at that date of the first earthquake. New residential units, so on vacant sections within the residentially zoned land, restrict discretionary activities, with matters of discretion focusing on minimising risk by, amongst other, design. But subdivision to create new allotments within these areas is still a non-compliant activity. So difficult to obtain. So to subdivide existing allotments. I think that's probably sort of consistent with, that last one is directly consistent with the New Zealand Coastal Policy Statement in terms of intensification and new development. No, so the above provisions they were inserted by Minister Woods under the Greater Christchurch Regeneration Act. Now, as part of the process for developing those amendments to the plan, that there was a level of opposition that said providing this exception for these areas did not give effect to the New Zealand Coastal Policy Statement, and that was rejected by the Minister in her decision. And she said she rejected on the basis that the Coastal Policy Statement contemplates mitigation of risk and not complete avoidance. Again, it's a consistent theme coming through here. And the final document, just what I really talk about, which is the Regional Policy Statement. This, in her decision, Minister Woods actually made specific reference to this document as well, and also to the submission on the Section 71 proposal by the Regional Council, who supported the proposal. But the Regional Policy Statement is 2013. So it postdates the New Zealand Coastal Policy Statement, so it's deemed to give effect to it. The Christchurch District Plan or any changes in the future must also give effect to this Regional Policy Statement. It's got a two-tiered approach to management of coastal hazards, and the starting point is avoidance. Again, that's consistent with the New Zealand Coastal Policy Statement as a starting point, but there are exceptions. And so the exception, well, the principal exception, which the Regional Council referred to in supporting the 71 proposal, which was in existing urban areas, again like South Shore, Red Cliffs, Brighton, the focus is on either avoidance or mitigation. So mitigation of risk is an acceptable outcome from a policy perspective, and it's also consistent with the higher order document, the New Zealand Coastal Policy Statement. That's it. Just a few brief concluding remarks. I'd say the consequence of, I mean, this is stating the obvious really, isn't it? Sea level inundation on existing coastal areas like Brighton, South Shore, Red Cliffs, must be greater than other undeveloped areas. It's simple common sense. But the probability of a hazard occurring to a damaging level within the 100-year time frame required by the Coastal Policy Statement, it's uncertain, and it's likely to be the subject of ongoing intense scrutiny and debate. And the policies are, so the policies of those higher order documents are going to be very influential in shaping the approach that the District Council or the City Council takes in its plan. The courts have consistently held that the Resource Management Act, it's not no risk at all, and but the Gallagher decision, I'll say it's most relevant in terms of a plan change, but it makes it clear new development, whatever that means, needs to be located away from areas prone to risk. And so from that point of view, I'd say, like as I said at the start, if you're looking at greenfields, if you're thinking about greenfield development within these high hazard areas, I think it's going to be very difficult to justify from a New Zealand Coastal Policy Statement perspective. But if you're talking about sort of minor intensification and extending your house or replacing your house, it's probably a different approach would be appropriate, in my humble opinion. That's it. happy to take any questions and to subsequently deflect them.